Our next case for consideration is 24-1912, and it's John Larson versus Chad Holmes. Mr. Sahag, you will be representing Mr. Larson, and Mr. Valencia, you will be representing Mr. Holmes today and providing arguments. So whenever you folks are ready, we're ready for you.
Counsel. Gross negligence claims under Iowa law are common law claims. And in Parent-Father Doe versus Dubuque County School District, the Iowa Supreme Court in May of 2025 of this year said that the qualified immunity provisions in 670 do not apply to Chapter 670 claims. Now, this is a 669 claim, and so what we're asking the court to do to say is, under the same rationale, the qualified immunity does not apply to 69 claims either.
Says that you don't have the heightened pleading requirements in the qualified immunity for common law claims, but only constitutional and statutory claims, right? I'm just curious, does the fact that 85.20 or 85.2 or 3, whichever ones, apply, does that take this gross negligence into the realm of a statutory claim instead of a common law claim?
It does not, and here's the reason why. Chapter 85 was a part of the grand bargain where there was the legislature said we're going to give absolute immunity to employers, but they carved out that absolute immunity and they pulled some of it back and said, except we're going to for gross negligence for common or co-employees, we're going to withdraw some of that immunity. But if you look at the text of Chapter 85, subsection 2, it doesn't give us the elements of a gross negligence claim. So we have to look to the common law for the elements of a gross negligence claim. So here's it.
The gross negligence claim always existed against the co-employees, but once 85 came in as part of the grand bargain, it basically immunized employers. But for that immunization, it carved out that and left alone that common law gross negligence claim. Is that the gist of it?
That's right. So it did not create a cause of action that did not already exist, right? And so that's the difference here. But you can also look back to the Supreme Court's decision in May, because what the court examined then the Dickey case, Dickey versus Mahaska County, and that case is a claim, civil rights claim based on Chapter 216. So, Judge Allers, it's a little bit, it goes to your question, I think, because what the court said there is, if you look at 216, Chapter 216 does not give a qualified immunity defense within the actual statute. And so it cited to a Southern District case that said heightened pleading does not apply to Iowa civil rights claims either. And why not? Because when you look at the statute, there's no qualified immunity in the statute. If we then go look at Chapter 85, there's no qualified immunity in Chapter 85. So it's both, right? So even, I guess even if you could say for some reason it falls under, it does fall under 85, there's no qualified immunity defense under Section 85. So it's a common law claim for those reasons.
Didn't have the benefit of Doe in this ruling, right?
Correct.
So, does that suggest that it would probably have gone a different way?
I don't think so. Well, that the court would have gone a different way. The district court, I think so. I mean, actually Doe came out, I believe this is the time frame, before I had to file a reply. So, I mean, from our perspective, it was kind of a good day when we read Doe and said, oh, I haven't had to file my reply yet. So we were able to cite to Doe. So, yeah, I think if the district court would have had the benefit of Doe, it wouldn't have had to engage in this particularity plausibility analysis that's been rife in our district court and appellate court system for the last few years, and once those statutes were enacted. And I think what the Supreme Court has said is started to try and really clarify what the intent of 6-7 or the qualified immunity statute was, and that was for these constitutional law claims and a 1983 claim, basically. And I think that's really what the Iowa Supreme Court has said, and maybe at some point it's going to have to weigh in and be even more clear. But but the qualified immunity applies to like 1983 claims and constitutional claims, not common law claims. And I think that the court's been very clear about that. Now, either way, though, I think even if this court were to say, well, I think you do have to plead with particularity and plausibility, I think we've done that anyway. And so I think the court can go either way. I mean, you could punt on the issue of does Doe mean that under 669 qualified immunity doesn't apply, because we pled this case with particularity and plausibility. And quite frankly, it might be a little bit quicker for us to get back into district court if you went that way, which we would like. So either way, I think it's almost like a heads I win, tails you lose scenario for us, because what the Nahas case said in 2023 is to plead a claim with particularity. You look at the newspaper, it's who, what, where, when, and how. And I think it's very clear that we hit every element in this petition for a gross negligence claim, knew of a danger, knew it was probable, not merely possible, and then consciously avoided the disregard. And we set that out in our briefing very clear.
Question about an absence in your reply brief. And I might be misunderstanding this. I'm going to ask opposing counsel about this. But as I understand that the opposing argument is the court kicked us out on a heightened pleading issue and then specifically said, but if it weren't for the heightened pleading issue, I would not be kicking it out on these other grounds, exclusivity and what have you, right? And I think they're arguing that, like, oh, we can, as an alternative, if we lose on this issue, on the heightened pleading, we then can win on these other two issues. And that has me scratching my head, because typically our rule is you can argue an alternative ground for affirming if you raised it below. But here they had an adverse ruling, which to me would require them to cross appeal if they're going to claim that alternative basis for affirming. And I'm just curious on your thoughts on that, if you have any. And I know that's a lot to throw at you right here, but I'm just...
My esteemed colleague who just argued before you, Gary Dickey, would probably be able to answer that right away for you. I would say that I just can't give you an exact pinpoint of what the law is on, if that's preserved or not, standing right here today without saying something that I just haven't looked at, and I don't want to misrepresent that to the court.
So punt.
So, I think when you look at the particularity standards here, though, what Nahas also says is, it says that what plausibility means is that you've got to allege facts that allow the court to reasonably infer liability. And so we don't have to plead every single fact. Courts can use their common sense and their judicial experience to say, is there enough here? And, it's not lost on me that in every case, the model jury instructions tell the jury to use their common sense. And what do we have here? We have a petition that pleads that there was a snowplow sitting on a skid loader with two forks. There were people around it, and you're moving it around. Well, what's going to happen? It's going to slide off and it's going to hurt somebody. That's common sense. And we've pled that this specific individual knew of the dangers. I don't think we have to plead how they know of the dangers. We pled they knew. That's admitted as fact. And so when you have a scenario where you're moving a massive piece of equipment around the vicinity of someone and you're not securing the load, I think anyone knows that's not just negligence, that's something more. And I think that's where the district court erred here, is the court went looking for other facts. Well, they didn't say this, and they didn't say this, and they didn't say this. But the court was able to infer that some of those facts probably exist. And so when the court is looking at the standards for motion to dismiss, number one, when they file a motion to dismiss, the facts are admitted as pled. That's number one. Number two, doubts are resolved in the non-moving party. And so if there was a doubt that a fact might existed, that should have been resolved in my client's favor, not to say, well, you didn't plead this. Because when you actually look at the facts, I think any reasonable person, doesn't have to be a judge, doesn't have to be a lawyer, can say, Somebody's going to get hurt when you move a snowplow around on metal. So for those reasons, we'd ask that the court reverse the decision of the district court and remand the case back for trial. Thank you.
Whenever you're ready. Start with, is this a different case now with Doe?
Thank you, Your Honor. May it please the court, counsel. The landscape for qualified immunity has changed since Doe and Kahn came out, but those changes do not require this court to reverse the grant of the motion to dismiss. And this court can affirm for any of three reasons. The first is, as to the court's subject matter jurisdiction, it does not have it because a state employee's exclusive remedy for a workers' comp claim is under workers' comp. The second is that even if the claim does exist for qualified immunity in Doe and in Kahn, the Supreme Court said that the qualified immunity applies to constitutional or statutory claims. A claim under the Iowa Tort Claims Act is a statutory claim because the common law claim for gross negligence did not exist as to a state co-employee in the common law. That's what the court said in Socorro this last summer, is that the state employees, just like the state, experience sovereign immunity from those claims. And so qualified immunity should still apply. That's the second reason. And then the third reason is even if ordinary pleading standards would apply, the plaintiffs have failed to show a right to recovery under the Thompson test. So I'd like to start with the co-employee gross negligence question and whether this court has subject matter jurisdiction. And to Judge Allers, your question about whether there needed to be a cross appeal or not, I don't think so, because this does go to jurisdiction.
I'm confused by, right? Typically what we see is you win below on issue number one, but you argued issues 1, 2, and 3, right? And either the trial court was silent on issues 2 and 3 or ruled in your favor on 2 and 3. And so you can argue, well, typically they wouldn't have ruled on your favor. They'd be challenging all three of those and they'd be right in front of us, right? But here we had issue number 1 was resolved in your favor, which understandably then you won, you don't need to appeal, right? But then they appeal and they challenge that one ground, right? And so as I understood your brief, what you're arguing is on issues 2 or 3, we could affirm alternatively on those two. But I don't see how you can do that when you have an adverse ruling. And quite frankly, I think that's why you get that 10-day sliver of additional time to file a cross appeal is for the party that won to say, oh, they're challenging the ground that I won on, but I think the trial court screwed up on issues 2 and 3, so I need to cross appeal, so in case I lose on issue number 1, I can get them to then reverse on issues 2 and 3, and I still win, right? So as I understood, you read your brief, you are arguing it almost as if you had won on the exclusivity issue and on the barred by the Iowa Tort Claims Act issue when the trial court expressly said you lose on those two issues. The only reason you're winning is because of the heightened pleadings.
Well, I think it's a different situation here because this is not any run-of-the-mill issue that we brought up. It goes to the court's jurisdiction. And so here, this court does need to determine as a threshold matter whether it has jurisdiction. And this goes to that. And so this court can affirm on that alternative lack of jurisdiction basis because here, if the exclusive remedy is under the Iowa Workers' Compensation Act, then this court has no jurisdiction over a statutory claim under the Iowa Tort Claims Act.
That it isn't exclusive.
I understood, and I think that courts at each stage have to assure themselves of jurisdiction. That's why jurisdiction can't be waived, and it's a subject matter jurisdiction issue here that the court has to grapple with at the threshold instance.
If it doesn't apply, the district court did have jurisdiction, right? And that's what the trial court ruled, and you didn't appeal that finding.
That's correct, and I think to your point, though, you could affirm on the alternative basis of a lack of jurisdiction. I don't think this court can assume that it has jurisdiction. If we were to raise a jurisdictional issue, the court has to assure itself of jurisdiction. Courts generally will not assume jurisdiction and go to the merits issues. That's what we're asking here. I think if you were to only decide the issue about the qualified immunity here, we would still win on that as well, because for qualified immunity, in Doe, the court said that those are for statutory claims only. This is a statutory claim, at least for state employees, because the state employees experience sovereign immunity at common law. So these aren't common law claims. If plaintiffs came to court and pledged just a straight up common law negligence action, there wouldn't be jurisdiction because they wouldn't have had followed the requirements of the Iowa Tort Claims Act. The Iowa Tort Claims Act provides a statutory right to plaintiffs to bring a claim against the state for things like property loss or damage, or personal injury or death that are caused by the negligent or wrongful conduct of a state employee in their course of employment. This is a statutory right given to plaintiffs under 669.2, and because of that, qualified immunity should still apply. This issue was not in front of the court in Doe or in Kahn. In Kahn, the court just applied Doe, but that issue had not been briefed. So this issue has not been decided yet by the Supreme Court, so you're not bound to just apply Kahn here. You could decide here that a claim under the Iowa Tort Claims Act is a statutory claim and then gets qualified immunity. And one more point on the co-employee gross negligence claim is I think if you step back 100 years to when the workers' comp was enacted in 1913, before that there was no claim against the state employees, and after that there was no claim against the state employees. So when 85.20 was amended in 1974, it was amended in response to a claim brought by private employees against their private employers, where the Iowa Supreme Court, and these cases are Price versus King and Craven, the Iowa Supreme Court said in those cases that a private employee could claim for ordinary negligence against their co-employee. So the legislature responded to that and restricted what was available at under 8520 and said, well, we need to be clearer to extinguish pre-existing common law claims, because the reasoning of Price versus King was the legislature did not clearly extinguish a pre-existing claim. Well, here, when you have a state employee, there is no pre-existing claim to extinguish. It's the opposite. You need a clear waiver of sovereign immunity. You need express language granting a claim, and here we don't have that. What you have is under 85.2, the text says that the exclusive means for payment of compensation for a workplace injury is workers' comp. Exclusive. Under 8520, you have similar language that the exclusive right and remedy is workers' comp subject to the gross negligence exception. Plaintiff's theory here would have to be that those two clauses, exclusivity clauses, do the same work. But that's not how we interpret statutes. They were enacted, both of those exclusivity clauses and their predecessor statutes were enacted at the same time in 1913. They were meant to do different work. And so we have to give 85.2 some width. And here what that is for a state employee, their exclusive remedy would be under workers' comp. But turning to the merits of their pleading, even under an ordinary pleading standard, you can affirm the decision below because the plaintiffs here have pled themselves out of court. They have, as the district court determined, they've only pled ordinary negligence. And there's two specific reasons for that under the second prong of the Thompson test. The second prong of the Thompson test says that you need to plead that injury, there's knowledge by the defendant that injury is probable, not just possible. And here they've pled that injury was just, that knowledge of injury was just possible. If you look at their pleadings in paragraphs 23 and 24 about the manufacturer warning, the manufacturer warning label just said that injury, quote, could occur. Could, under the Supreme Court's cases, is just knowledge of a possible injury, not probable. There's warning labels, as we're all familiar with, that say, if you swallow this chemical, injury will occur. But here they've only pled that the manufacturer warning label says could occur. So that's one reason why they've pled themselves out of court. The second is they've pled that there were 8 people standing next to this danger. And only one, they've pled himself, the plaintiff, was directed to stand there. The other 7 were not have pled to be directed to stand there. And under this court's reasoning, the Supreme Court's reasoning in Henrik, if other people are standing around the danger, it's not plausible inference to determine that they too thought injury was probable, that this injury was probable to occur as opposed to just possible. So here, they've twice over pled that injury was merely just possible. They haven't pled enough to show that injury here was probable. And so this case is pretty similar, I think, to one of this court's cases, Justice v. Anderson, where you had a defendant that redesigned a warehouse where the warehouse was storing boxes of paper. And the defendant redesigned it to say, instead of stacking those boxes 3 high, we're now going to stack them 4 high. When the defendant did this, he saw that the boxes started tilting a little more. It was proven that he knew those boxes would tilt more if they were 4 high. It was proven that he knew that if they were tilting, they were more likely to fall. And it was proven that if they fell, they were likely to hurt somebody. But what was missing was knowledge that injury was probable. So even when you have something that might be deemed a risk, or I can see that danger might happen, just because something might happen over time if you do it over and over is not enough. It has to be that in this moment, in this zone of imminent danger, the defendant knows that injury is probable, not just possible. And here, under the pleadings, all we have is knowledge, even under the ordinary pleading standards, knowledge that injury at most was possible. So for any of those three reasons, this court could affirm the dismissal of this case. Thank you.
Thank you, may it please the court. I'll just start where the counsel finished off. First of all, the counsel mentioned that there's not enough in the petition to show probability as to mere possibility. So I would point the court, well, first of all, I would say, they've cherry-picked two averments in a petition that is several pages long. And so what the court's got to look at here is, it's not just about 18 and 19. It's also about where my client was standing in the immediate vicinity. And so that's what creates the probability. It's the knowledge coupled with standing next to the danger in that immediate zone of danger. And I'll point the court to our pleading too, our petition. I mean, we literally plead, Holmes consciously availed to avoid the known peril to a probable injury to Larson by moving the unsecured snowplow in Larson's vicinity. That's in 27. That's got to be taken as true. So I don't know how they cherry pick 18 and 19 when 27s exist. 26 as well, Holmes consciously failed to avoid the peril to a probable injury to Larson by failing to tell Larson to move away from the area where he was moving the snowplow. They don't want to talk about paragraph 26 either. So, and those are taken to be true. So, I mean, maybe if you only read 18 and 19, you could say, well, Mr. Larson, you got a problem. But we've got a lot of other paragraphs.
Argument with respect, there's other people standing in the vicinity.
So, I mean, it's a factor, but it doesn't change the outcome here. And I think the Henrik decision actually guides us here. And for the reasons we set forth in our brief, it's distinguishable. In Henrik, there was a standard practice for them to be skinning these animals or whatever it was, like 4 million times. And everybody was doing it. So here, what you have is you have a scenario where Holmes, who was the supervisor, created the danger. Right, so that takes it outside of Henrik. Second, let's see, I lost my spot here. In Henrik, you also had the scenario where the individual are not exposed to the same risk. So the 8 people standing on the ground in the imminent zone were exposed to the risk where the snowball could fall off. That's different for the person that was actually operating the skid loader. He was not exposed to the same risk. So Henrik is distinguishable there as well. Third, Henrik was decided after a full-blown trial. I mean, we're here at the motion to dismiss stage. And I think, we cited a case which is Turner. It was a trust case. And it was maybe one of these cases or somewhere else. But what the court's been very clear about is, even on the flimsiest of cases at the motion to dismiss stage, it's a little bit better to exert some professional patience and allow these proceedings to take course. I mean, if we look at Henrik, I mean, I don't know if there was a motion to dismiss or not, but the court clearly thought we should be patient and wait till the end of the proceeding to decide whether or not this claim is one that can survive as well. And then fourth, this danger is obvious, which is unlike Henrik. They've been skinning these butts or whatever it was called for 4 million times. Here, this was the first time that it happened. And also, it's obvious. I mean, you're moving hundreds of pounds of steel next to people's feet. I mean, it's an obvious danger. So it takes it outside of Henrik, to answer your question.
Court order, the court indicated and kind of framed your arguments about that it made serious injury probable as opposed to merely possible. Larson also alleges that it was a state policy to move equipment, and that wasn't followed, and that there were manufacturer warnings that were not followed. So, I mean, that's how the court framed it.
Framed it as probable as opposed to possible. I agree with that. And here's here are the 2 cases we cited in our brief, which one is the Nelson case, and 2 is the Alden case. And those cases were resolved in summary judgment. And what the court said specifically is warnings matter. I think in one of the cases, it was a supervisor warning. And it said when there's a warning, right, that creates a genuine issue of material fact as to probability as opposed to possibility. We're not even there yet. We're at the pleading stage. And to your point, the court seemed to contradict itself when the court said there wasn't enough and then examined how there was probability within the petition. And so for all those reasons, we'd ask this court to reverse the district court's decision, remand the case back for trial. Thank you.
For the excellent arguments today and the great briefing to help us. We will consider 24-1912 Larson versus Holmes to be submitted, and my colleagues and I will get a ruling out as soon as we can. Thank you.